A failed breathalyzer test can't form the basis for firing a worker. This is the precedent set by the Labour Court in a recent judgment. It upheld a CCMA ruling which found a dismissal by Samancor Chrome was substantively unfair. It ordered the employee's reinstatement with retrospective effect. Osborne Molatudi, employment law specialist at Molatudi Attorneys, joins us now for more. And Osborne, thank you so much for your time. What makes this ruling particularly significant to you?
I think what makes it significant is that breathalyzer tests are not conclusively something to be relied upon by an employer in order to justify a dismissal of an employee who may have breached that employer's rule in the workplace. So in essence, it doesn't take away the employer's prerogative to set rules in their respective workplaces, such as in the mining sector, in this case, where the rule will be against consumption of alcohol, reporting to work under the influence of alcohol or other intoxicating substances. Now, when an employee is alleged to have breached that rule, it is expected of the employer to present evidence to prove that indeed that employee breached the rule, and in addition, to substantiate why that employee should be dismissed, and not necessarily to rely solely on the results of breathalyzer tests. And gave reasons, the commissioner in the CCMA gave reasons for that ruling.
So with that being said, is the issue the breathalyzer that perhaps more tests should have been done, such as blood tests, to inform the employer's decision?
Indeed. The challenge in this particular instance was that there was expert testimony that was presented by a chemical pathologist. Amongst others, the expert testimony was to the effect that breathalyzer tests may, in some instances, produce false positive results, and therefore, a blood sample laboratory assessment is more accurate and reliable than a breathalyzer test. One must remember that most employers would adopt this breathalyzer testing because it's quite easy and quicker to undertake. But a caution emanating from this judgment is that those employers must put more than just relying on the results thereof. For instance, physical observations of the employee, whether or not the faculties of the employee were impaired to carry out his or her duties to a full extent, and whether indeed there is a rule against alcohol consumption. In this instance, the employer argued that it was a zero tolerance rule and not necessarily to prove that the employee was intoxicated.
Yeah, so in that instance then, Osborne, I mean, what does the employer do if they do have that policy in place within the workplace? Just to guide also future employers dealing with this matter and perhaps, or rather in the same situation at the CCMA, as I can understand, some may have that zero tolerance policy.
I think the general advice is that employers should do more than just doing a breathalyzer test. In their disciplinary code and procedures, they need to make provision for consent to obtain a blood sample from the affected employee. And of course, thereafter send the employee home pending the outcome of the blood sample clinical assessment, as well as any further investigation. I must emphasize that for the employees, it's not enough to plead that as much as I may have breached the rule, I wasn't intoxicated to the extent that I was unable to perform my duties. That is not the defense. But at the same time, employers need to do more than just relying on the test results of a breathalyzer. And especially if you're going to present an expert testimony in addition to relying on the results of the breathalyzer test.
Yeah, and you're a bit ahead of me there because besides the advice of the employer, my next question was, what's then the advice for employees in this regard? What's the lesson that employees can also take from this ruling?
I think on a light note, this judgment does not open what you call azipuzeni or drinks for all kind of session party in a workplace. It simply says that an employer cannot rely on a breathalyzer test alone, but it doesn't mean that the employee can then take a chance and report to work under the influence of alcohol or even drink on duty, and especially in areas where it may be extremely dangerous to other fellow employees or to even the employee himself. For instance, employees that have duties including driving of cranes, forklift drivers, trucks, you name it. So on that basis, it is still prohibited for an employee to report to duty under the influence of alcohol and or to drink on duty, again, on a light note, under asipuzeni kind of assertion in that workplace emanating from this judgment. It doesn't say so.
Yeah, and I think that could have been taken that way. But thank you so much for this conversation. Also just retrieving some of the lessons learned there. Osborne Molatudi, employment law specialist at Molatudi Attorneys, joining us right here on Newslink.